evening, and welcome to tonight's show. I'm your host, Tina Dawson, the owner of True Blue Designs, and it is truly an honor to be before you this evening. Please like and share and let everyone know that we are on the air. We are streaming simultaneously on Facebook and on our YouTube channel. You all are in for a treat tonight. This young lady, Attorney Levine, was referred to the show. She is an employment attorney, and we were just talking before the show. And I am going to tell you, get some paper and get a pencil or a pen, because Attorney Levine is getting ready to give you some information that is going to help you, whether you're an employer, whether you're a business owner, or whether you are an employee. She has a lot of information. We were just talking just in general, and I learned a lot within the 30 minutes we were talking. So I am just so excited to introduce you to Attorney Levine. I'm going to read you a little intro on her. Attorney Bonnie Levine is a certified workplace investigator, executive coach, and licensed attorney representing organizations and individuals navigating workplace change. Attorney Levine specializes in respectful workplace initiatives, DEI, which is diversity, equity, and inclusion, cross border distributed workforce management, and sustainable growth strategies. Help me give a warm welcome to tonight's guest, Attorney Bonnie Levine. Let's see if I can get you on here. There we
go.
Thank you so much for being on the show.
Thank you so much for having me. It's a pleasure.
I am so excited. Look, I almost forgot to bring you live because we were so in the conversation that we were having. Sometimes, Attorney Levine, it's just nice to know that someone hears you. I was telling somebody the other day, sometimes people don't want you to do anything. Sometimes people just want to be heard, and I think that the services that your firm offers could really help people. We were talking about earlier that sometimes people are just quick to be wanting to sue, right? And if you have a good attorney that could talk to you about your situation, sometimes suing is not the where you should go. You shouldn't go in that direction, right? Because there's a lot of other directions that you probably could go in, if that makes sense.
It's certainly, suing is always a last resort in the sense that it's really costly. Yeah. And that legal services are not as accessible as they should be for the populations that need them the most. And as an employment lawyer, I represented employers, mostly large employers at a large law firm for about 10 years. And we realized that, smaller businesses don't always have access to that type of legal advice. And, it's a really important specialty because your people are what helps you comply with the other laws. So without your people, you really don't, you can't get anything done. So I'm very, biased in favor of my specialty, but I think it's a very important area of law.
It really is. It really is. So I'm going to let you start off by telling the viewers a little bit about yourself.
Sure. So my name's Bonnie Levine. I am an employment lawyer, and I grew up in Williamsburg, Virginia, and then moved to Atlanta after law school. Went to law school in Michigan, and then moved to Atlanta. I have a sister who lives in Atlanta and went to Georgia State. And so I clerked for a judge here, and then I ended up staying here. I really liked it here in Atlanta. And I got a job at a small employment law firm, and then I went to a larger employment law firm. And then, recently decided to go out on my own about 6 months ago. So it's kind of new, but very exciting.
Well, your company may be new, but the information that you have a lot of, you're very seasoned in your specialty.
It's hard to believe I've been practicing for over 15 years, but yeah, but I really, employment law is great because really everything you're doing matters to someone and it affects their life. And so it's really meaningful to try to get to a fair result, whether you're representing an employer or an employee. It really matters to people.
Yeah, it does. So how did you decide? What was it that made you decide to go into your specialty of law?
It's really funny because, and I didn't even take an employment law class in law school. It was so weird. In law school, I was all over the place. I was like, do I want to do corporate, bankruptcy? I was just thinking of everything except employment law, which is especially crazy because the whole reason I decided to go to law school was because I had gone after college. I had spent a year in China. And I didn't even want to be a lawyer before that. But when I was over there, I was an employee in China with an employment contract that they tried to basically take away some benefits on. And I was like, wait a second, this doesn't seem right. This doesn't seem fair. Maybe I should study the law, lots of different areas of law. And employment law is known for being very facty, so like there's some areas of law that's all about really dense regulations. Employment law is about the people. It's about facts. It's about credibility. It's about emotion. It's about treating people fairly. It's about people's identities. It's about power. So it can get very messy because when a judge has to decide an issue of employment law, often, it's a question of facts. You hear the he said, she said type thing for like an investigation. Is like, how do you decide when all you have is one person's word against the others?
Right.
And the answer is you have to, right? The fact finder has to do that. So if it's a jury, the jury has to decide who they believe. I do workplace investigations. I have to decide who I believe. And there's a process by which you evaluate evidence. You look for corroboration. You look for credibility factors. But you really owe it to, in employment law, it's very important that you have someone make a decision on the facts. And that was really interesting to me because it's a harder thing to do than to apply the law, because sometimes you have to decide who's telling the truth. And sometimes two people can be telling their own truth and still one of them is wrong.
Right.
So I'm not scared of that type of mess. So I was really drawn to that.
They say, growing up, I've always heard there's three sides to the truth: his side, her side, and the truth.
Yeah, probably more than that.
probably more than that. Yes. So, so with your firm, what services do you offer? Do you strictly, what's the word? Do you strictly work for the employer? Or is it big corporations or small corporations? So who do you serve?
Right now, that's a hard question to answer because I'm still kind of figuring it out. I'm doing a mix of work, but really what I want to do is help move workplaces to be better, to walk their talk more. And I don't know exactly how that happens. I'm figuring out how best to make that happen, right? And sometimes it might be, if an organization wants counseling, great. If an organization needs an outside independent investigator to help them figure out what's going on in an internal situation, That's a very meaningful role that I really enjoy. And then finally, if people are not being treated well and their workplace will not, I think you opened by saying like sometimes lawsuits aren't, the first, you don't want to just run off and sue.
Right.
Ideally you don't, but sometimes you have to, because, and I think this is a problem and I'd like it not to be this way, but decisions in organizations often are driven by, we're scared of a lawsuit. So we're going to do this because we're scared of getting this type of lawsuit. And often that's a really distorted way of thinking. I'm trying to reframe it in a more accurate way when I counsel organizations. But the short answer to your question is, I don't have a particular limitation on my client base. What I do have a limitation on is, unless you are in alignment with the value system that, that I have, whether you're an individual or an organization, a small organization or a large organization, that's really the important thing. Do you want to advance workplace change? And do you want to advance equity in the workplace? And if the answer to that question is yes, genuinely yes, then I would consider myself a good lawyer for you. But if your answer is, I don't know, then maybe I'm not the best lawyer for you. So I think eventually I'll narrow it down. I have two executive coaches, both of whom keep telling me to focus. So, but right now I'm in exploratory mode. So ask me again in a year, maybe.
Look, I have to have you back on the show.
I accept.
Earlier we were talking about within the last couple of years, how a lot of companies have now formed a DEI department that was not there a couple of years ago. Can you just talk a little bit about the Department of Diversity, Equity, and Inclusion, and why it's so important for these companies to have?
So it's fascinating. And just going a little bit earlier than what we were talking about. So at the law firm that I was with, the large law firm that I was with before I started my law firm, Verse Legal, is called Ogletree Deakins. And we had a diversity and inclusion client-facing practice group in 2017.
Oh, wow.
And yes, and I was one of the founding members of it. There were Kemia Johnson, who's now at Jackson Lewis, was the practice group chair, and we were tiny. And I don't want to say nobody paid attention to us, but it was a small group. We didn't have like a high volume of work coming in. We weren't overwhelmed, right? And I was also doing mostly cross-border work at the time. This was just something that I was interested in helping develop. And, we were doing things, we were going about our business, and the pandemic happened, right? And that was a big change. And then, about 2 months later, George Floyd was murdered.
Right.
And after that, suddenly our little group was overflowing with requests from clients who suddenly desperately needed to get into this space. And I think that again, that was a good development, undeniably a good development. The problem was, though, that a lot of those companies didn't know what they were getting into. And they wanted to, I think that at least most of the clients that I worked with, their intentions were in the right place, but there was a panic about it. And there was like a panicked sense of like, gotta hire somebody right now. And but they did, right? But then they sort of expected that to be enough sometimes, right? It's like, okay, we can hire this person and then just not worry about it anymore.
Right.
And so you see that the space is evolving where, some companies are now they weren't prepared to actually do the work.
Mm.
And that causes a lot of problems. It causes a lot of problems for the person who they hired, who's trying to do their job.
Right.
And is basically, it's that they're being told like, no, that's not your job. And well, no, yes, it is my job. That's what you hired me to do.
Right.
So there's an evolution of the space where right now we're in this point where there's, and I love this, there's been an increased use of the word performative, which I love that word. I think it really captures it. And now we're at the space where, it's not enough to be performative.
Right.
You actually need to go beyond that. And that's causing some pain within organizations who are trying to figure that out. So it has been, it's been an interesting time. Mm-hmm. But I think the biggest issue really is that there aren't a lot of laws about what you can do. There's a few laws about what you can't do. And therefore, the diversity departments, the DEI departments, and the legal departments aren't always talking to each other. And then what'll happen is that, they'll have a DEI initiative and then bring it to legal, and legal, who often doesn't know anything about diversity and inclusion, will be like, no, can't do this. Right. And then, it just often, I've seen it happen enough times that I think the conversation needs to change. Right. So that's, and we're working there, there's a lot of, it's starting, right? I'm starting to see more attorneys getting, learning and thinking about this differently. Mm-hmm. But I think it's really difficult for employment attorneys who are very, very entrenched in the rhetoric of Title VII, mm-hmm. which is about, as we were talking about earlier, intentional discrimination. Right. And that really is that framework is limiting mm-hmm. in some ways. And when attorneys are only looking at it through that lens, they're not going to see the whole picture. Right. Yeah. And earlier you and I were talking about behaviors, right? Mm-hmm. So they hired these DEI people to work, created this in department, hired somebody to work in the department, and said, okay, now you have to deal with all these type of complaints or issues that come up, right? Yeah. But on the other side, over here, the behavior didn't change. So right. Like you were saying, I think that ties the DEI person's hand. Mm-hmm. Right. So it's yes. So and what you said something really interesting just now that I think is really important for corporations to pay attention, or employers to pay attention to, which is you hire a DEI person and then you put the entire burden of DEI on that person. That's really not what DEI is. DEI is about the people who have the power taking on the burden. Mm-hmm. And the function of a DEI officer is to advocate, to help, but it's not to make you not have to think about it anymore. Right. Right. Quite the opposite. That's not what inclusion is. And so you see, you see, like I would say, a CEO, the CEOs need to really think about the signals that they're sending. Mm-hmm. Because a CEO who's like checked out, there's two, I've seen a couple different types, right? There's a CEO who's like just kind of checked out. It's like, oh, I hired this person to do that, so I don't have to think about it, right? That's one type. Again, that doesn't work. It signals to the workforce that you just don't want to worry about it and you're just checking a box. Mm-hmm. And then there's the CEO who is, treats DEI the same way they treat like a product issue. And they like are really hard driving. And they're like, I need my diverse workforce now, right? And so they put a ton of pressure on the entire workforce. And now everybody's super anxious. And then that's where they're likely to make mistakes. And also like really tokenize people. And it's really short-sighted, right?
Yeah.
So like that's another type of CEO. But I think that the myth of, okay, I'm just going to hire a DEI officer and then not think about it anymore is what the problem is.
Right.
And I think that the problem now that DEI officers have is that they know that. I mean, what I just said, they know that, but it's, it's how to message that to their CEO. Like, no, you have to care about this. And it's, it's very difficult, but I think it's like, I mean, you asked why they should have a department. And I think, look, once you get big enough, yes, it's probably in this day and age, you need to have the function in sort of a formalized way.
Right.
But ideally, what I like to think of DEI as not too much of a silo, because if you silo it, then it makes people think like, oh, I don't have to think about it. When really it should be like an overlay over the entire organization. Is that we should not be thinking like, okay, so DEI is only this department over here. DEI is a way of thinking that we apply to product, that we apply to basically all business decision making. And in particular, I would like to see more application of DEI to legal decision making. And that's where I think it's missing a lot. They're not thinking about DEI as something that you need to think about in decision making.
Right. In all decision making.
Exactly.
Right. Yeah. They got their hands full. They got their hands tied and they got their hands full. My heart goes, I think it's really needed. But like you were saying, if you don't structure it right, you can have turnover in that department.
Yes, absolutely. It's and I think that what's really hard about it is that people get into DEI because they're passionate about the work, and often that passion comes in part or in whole from lived experiences of discrimination, of institutional, sexism, racism, throughout their lives. And if organizations don't honor that, if they take advantage of that, and they basically take advantage that you've got someone who is truly committed, you got to really honor, like you got to really respect that, because otherwise you will end up breaking the law. Because like, if you don't respect that person is truly like this person, I don't think people go into DEI just to collect a paycheck, because that's like a very, as you said, it's a very hard, it's a very hard job to do. But again, I see organizations, they don't consider the implications of that. And so it's really like the employees that are sort of the easiest to intentionally or unintentionally abuse are the employees who are so committed that they're going to give their all to this. And again, if you're sitting in your place of power and not really thinking that through, that is where I see most of the legal risk in this space. But nobody's talking about it.
Right. Yeah, you're right. You and I talked about earlier that Georgia was an at-will state. Can you explain a little bit of what that means?
Yeah. So at-will employment, it is a creature of U.S. employment law, and almost all of the states are at-will states. And what it means is that either, by default, right? By default, either the employer or the employee can end the employment relationship without notice or payment. And that's a unique creature of U.S. employment law. Outside the U.S., I don't think there is a single country on the planet that lets employers fire someone without notice or payment when they didn't even do anything wrong. I mean, in most countries, the only way you can fire someone without notice or payment is if they committed some kind of gross misconduct. And here, it's completely different. Employers feel basically free to terminate the relationship for any reason except for a discrimination or retaliation or, some kind of reason along those lines. That's just not the way it is anywhere else in the world. Georgia is, I would say, in the US, which, again, I think maybe Montana is the only one that's is truly like not at will. I might have gotten that wrong, but most states are still are at will. But there are states that have more regulations than Georgia. So California has more employee protections, specialized employment statutes. New York is the other state that I have the bar license in, more specific employment legislation. Georgia, not many protections for employees.
Right.
Pretty much you have the federal protections like the Fair Labor Standards Act and the federal anti-discrimination laws. And again, there's some Georgia law, but by and large, it's employer friendly here, not employee.
That's what I thought. Yeah. Yeah, that's what I thought. Wow. Now, also, we were talking about, I'm trying to remember because it was a good conversation we had, but we were talking about how if you felt that you've been discriminated against, that there are steps that you have to go through. And we were talking about the EEOC. So can you talk about that?
Yes.
and what their purpose is?
Oh, the purpose. Well, so the EEOC is a federal agency, and some states have their own, like in New York, and like there's a New York Human Rights Agency that, it also exists. But in Georgia, really, it's the EEOC. If you feel you've been discriminated against, before you can file a lawsuit, you have to go through the EEOC process. You have to file what's called a charge of discrimination. You don't need an attorney to do that. It helps, right? Because, there's a lot of ways in which it helps. An attorney can help you, phrase it in a way that like will more easily establish the elements of a cause of action, but you don't need an attorney to go through that process. And then during the EEOC process, in theory, right, it's designed to help facilitate settlements, and it's designed to weed out, cases that people aren't serious about. Right. One can debate how functional it is, and especially right now, they're backlogged big time.
I can imagine.
It's I filed a charge in December, and I just got it scheduled for mediation like last week. Wow. So it's, this client of mine is still working for that company. It is very hard to continue working for a company that you've filed a charge of discrimination against. I mean, that's just like a lot of emotional burden to have to continue working in that environment. But some people don't know, as you pointed out, that you have to do that or else you can't file a lawsuit. Like if you file a lawsuit before filing that, before going through the EEOC process, you're probably going to get kicked out because you didn't go through the EEOC process. And you just have to do that first. And what's really crazy is that you before you can do the EEOC process, or not before, but you got to check to see what you signed, because a lot of employers require employees to sign arbitration agreements, sometimes agreements that actually shorten the statute of limitations. And statute of limitations means, like you can't bring really old claims. Right. And for the EEOC process, it's pretty quick. It's already, like 6 months from the time that the events occurred. Approximately. It differs by state. But, often employees don't even realize that they've signed something that limits their choices in terms of bringing a case.
Yeah, I think a lot of times when we're so excited that we were hired, we all
That's
have
right.
to sign a stack of papers, and a lot
Yep.
of times we don't read it until something happens, and then we go back and read it, and then I didn't know what I was signing, and I've watched a lot of shows, and I didn't know what I was signing. Does not work in a court of law. It does not work.
No, and Georgia, in Georgia, these types of clauses are largely enforceable. Now there's limits to that.
Mm-hmm.
You can't fraudulently coerce someone into signing things. And,
Right.
I'm actually making some arguments in a case that I have pending now about an arbitration agreement that I don't believe was enforceable. But the law is not clear on it. It's definitely not clearly, that they won't enforce it. And arbitration can be expensive, and it's often confidential.
Mm-hmm.
So it's and like you said, if you just got a job, you're going to be signing the paperwork because you don't really have a choice.
Right.
And what's interesting again is that in the U.S., this is a unique phenomenon to the U.S. In other countries, they sort of recognize that power dynamic.
Mm-hmm.
And, it's almost in most other countries, they do not let employment claims go to arbitration. That's uniquely in the U.S.
Really?
Mm-hmm.
We need to study abroad.
It's really like being an international employment attorney. It's like, especially I had two kids while I was at Ogletree. I'm like, all these countries that have year-long maternity leaves and like everything's paid, and then
really?
here, yeah,
a year.
Yes, in some countries, they your job is protected for a year, and most countries have at least some paid maternity leave that is required by law.
Not 6 weeks.
Usually more than 6 weeks.
Wow. Yeah, I've heard of some people, mostly teachers. It was way before COVID, but they would get teaching positions overseas, in other countries, and they would say that the laws were totally different and more employee friendly than the U.S.
Yep, it's I can attest that is certainly my experience, that the laws in other countries really give employees sort of some basic rights to not be terminated without notice, to receive payment. And then some countries are more protective, and you actually have to have a valid reason to terminate someone.
Right.
And there are problems with any system, right? It's like I specialized at Ogletree. I specialized in Asia. And in Asia, a lot of those employment laws are lifetime employment, meaning you really, like, an employer cannot fire anyone.
Wow.
Yeah. So basically you have to negotiate a resignation. You end up paying someone, right? So, but you can't fire them. Like, you can't unilaterally fire them, basically, unless they commit really gross misconduct.
Right.
So basically it's in China, it's called iron rice bowl. There's this phrase. And it means that you are employed until you reach retirement age.
Okay.
So retirement age is when employers are allowed to terminate the relationship, and it's not really expected to happen before. I think that has its own problems. I mean, it has its own problems, but I think the at-will employment structure is, I think that we have some serious issues with, the way employers, I think they've just kind of learned in this country, in this system, it has not been a priority to value or respect
Mm-hmm.
employees.
Mm-hmm.
And I don't want to get too deep in this, but chapter 8 of the 1619 Project explains where this came from. And it's we really have to look at these systems and whether they're serving who they're serving, right? Who are they serving, and what can we do about it? And that's part of the struggle in as an employment lawyer, because employers have a lot of discretion to do what they want in this country.
Yeah.
And there's not a lot of recourse that employees have against employers, private businesses, when that happens. Now, there's exceptions, right?
Uh-huh.
Federal government employees, tenured professors. There's industries in which that's not the case, and there's some unionization, but the percentage of the percentage of the workforce that's unionized in the U.S. is far lower than in many other countries, and that it leaves employees relatively powerless. So that what's interesting, going back to the DEI function conversation, is that in other countries, what's funny about it is you hear global companies and their abroad offices are like, oh, well, DEI is a US issue. That's not right, but it's also it's a little bit right in the sense that the US needs DEI in a way that other countries don't, because the US workers have no statutory mechanism to be heard.
Right.
And in Europe, there's something called a works council. So it's almost like legislated DEI, because the workers have a voice. You have to elect a council. It's not the same. However, I think that it's important for both of the subsidiaries in other countries, and this comes up mostly with U.S. headquartered companies. I think it's important to sort of understand the background of the fundamental disconnect between U.S. employment law, which is at will, and other countries' employment laws, which are based on employment contracts and sort of a basic understanding of employee rights.
Right. So if there is basically based on employee contracts, then if they don't do something, they can basically get them for breach of contract.
Right. So,
okay.
If you take a country like Canada is a common example, because it's relatively close to the United States in the sense that employers have at least in most provinces in Canada, they have flexibility, a high degree of flexibility to terminate an employee relationship, but they have to pay a minimum amount of notice. So usually it's based on the length of service. So if somebody's worked for a company for 5 years, usually they get at least a week's pay per year of service at least. Okay. And it's by contract, and usually you write it out at the beginning of the relationship. So when either party wants to terminate the relationship, you give this much notice or payment in lieu of notice. So that's one model. And then there's the lifetime employment model from Asian countries. And then there's the European model, which many countries, with the works councils, there's a whole sort of collective bargaining system. In Latin America and Europe, they're common to, bargain collectively as employees, which again, it's just different. And I don't know if you've had experience with unions here, but here, when you think of a union, you think of a campaign where the employer gets to oppose. In most other countries, they don't have that. If you want a union, you can just get one. The employer doesn't get to oppose it. So it's really, and I think that there's a lot more room for both, because companies in Europe don't understand that US doesn't have employment contracts. Unless they've worked with US companies before, it doesn't occur to them. Because it's just so fundamental that every employee would have an employment contract.
Wow. I think if we did, it'd make our lives a lot better as far as employees.
Yeah, I think that there's something there, right?
Yeah.
I think that and frankly, I think it would be better for employers too.
Mm-hmm.
I don't think at-will employment works for employers or employees, because employers faced with at-will employment have pressure to fire people without paying them. But like in an employment contract system, if you can fire someone if you pay them.
Right.
And so it's just, I think it provides a little bit more fairness, certainty, and the opportunity to sort of agree up front on what the terms are.
What the terms are, yeah.
So.
Yeah. Wow. Okay. So let me ask you this. How do you think companies or managers can create a diverse, equitable, and inclusive workplace?
Wow. That's the question, isn't it? I think that they cannot wave a magic wand and do it. That's one thing. They cannot just hire somebody and expect to never have to think about it again. The first thing they have to do is listen and realize that it's a listening exercise first. And not a marketing exercise. So I always ask, when I look at companies, I look, like, who is the target of your DEI efforts? If it's the customers, that's a signal that you might not be doing it right. Like if you're doing only things that you can put on your social media feed, you just got to think about that and think about and be honest with yourself, right? Companies need to be sort of honest with themselves, and they shouldn't be so quick to make statements they can't back up. Because in my experience, when a company that, talks a big game and then doesn't deliver on it can cause a lot of, and we were talking earlier, the sweeping under the rug phenomenon. And so you have to realize the power of narrative. And there's, if you create a narrative and your narrative is, we are the most inclusive, equitable, diverse company ever, we're awesome. I mean, it's great that you want to say that, but you got to realize that you can't just say that and then have it be true.
Right.
In fact, if you say that, you have to watch even more closely to make sure that people are being treated in accordance with your values. Because what happens is, if the outward-facing marketing says all of that, is really emphatic about that point, people will feel even more intimidated in some ways to say, it's not true,
Right.
Because you feel like you're gutting the identity of the company. So how to do it, I don't have the answer. I wish I did. I can tell you a few ways not to do it. But the quickest way is listen to find ways to listen to people that you don't know. You've never listened to before.
Yeah. And I also think that they've got to be willing to change. Right. Because we were talking earlier about, you end up getting a DEI department, but then you want to still, do things the same way.
Right.
And it doesn't work.
No.
Right. Because times are changing, things are changing, and the DEI department is there to help you. It really is there to help you. But when you don't want to change and you deal with that, or like you mentioned once before, the DEI person says, well, this is what's going on, and this is my recommendation of what we need to do. And then the, person of power says, no, we're not doing that. Then that person's hands are tied. And I think that, like you were saying earlier, you're opening up a bigger can of worms, because now you have this DEI department, and then everybody now knows it's supposed to do something. And then you go to that person, the person says no, you're opening up a bigger can of worms. You've got to listen, but you've got to be willing to change.
Right. And it's not only do you have to be willing to change, you have to be willing. You have to be willing for your brain to hurt sometimes, right? There's there's always like, it's, like there's, it's okay. I have this phrase I use in my coaching sometimes, like when I'll have, and I always talk about my husband in my coaching sessions, because like it helps, especially when I'm coaching. Like I often do one-on-one coachings after someone has been investigated for, microaggressions or bullying or harassment or, sexual harassment, something that maybe they unintentionally did something and had a harmful impact, but didn't, intentionally discriminate or didn't, intentionally harass someone, but they need to learn about their impact. So I often talk about my husband. He knows this, but I talk about him because I want to sort of signal to this person, like good people that I married, right? Make mistakes. And the most important thing is that you can listen and learn and grow from those mistakes, and not, feel like your entire, your ego will be sort of, you'll sort of fall into a puddle on the floor just because you got called out on making a mistake. Right. And so when I do these coachings, I try to sort of talk about how it's okay for your brain to hurt sometimes, and it's new, right? It's new. And like the example I give, and again, not to throw my husband under the bus too much, but like when we have a friend whose pronouns, uses they pronouns. Okay. And so my husband will be talking to me, right? And then we'll just misgender that person. And then you can see he's like, his brain is hurting, and he's like, oh gosh, why is it so hard? And so I always say, I was like, okay, you get a tiny violin for that, right? Because like, it's like, you can do it, right? This burden that we're placing on people who have never had to think about race before because they were white, or they never had to think about gender pronouns before because they're cisgender. They can handle just a little bit of extra resources to be thinking about those things that other people have had to think about all their lives. Right. And so sometimes it's like, because they feel like it shouldn't be hard because it's never been hard for them. But it's okay for it to be a little hard. And I think that's really the bigger answer to the question. It's okay for it to be hard. It's a little hard. It's new. It's okay. It's okay for it to be a little hard, and it's okay to learn.
And I think in it being hard, there's growth.
Yes.
Right? Because if you're open to, like you said, listening, there's growth in that. Right. You mentioned earlier about the law of intent, or the intent of the person. And we were talking about how it's so hard to prove what someone's, really intention was, right? So let's talk about the law and intent. Let's talk a little bit about that, what we were talking about earlier. I thought that was a good conversation.
Yeah, it's so tough because our discrimination laws are built around the intention of the decision maker. The two types of discrimination under Title VII of the Civil Rights Act of 1964 are called disparate treatment and disparate impact. And, I'll try not to get too far into the weeds of it, but disparate treatment is really intentional discrimination. There's an element of intention that, that needs to be proven. And as you said, it's very, very difficult. And honestly, it's even more difficult than it should be because of the way the judicial decisions have created this doctrine where the plaintiff has to prove 3 things, then it shifts. So basically, if someone gets fired and, the plaintiff, which is the employee who's suing the employer, says, you discriminated against me, they have to sort of establish basics. So it starts out with them, and then it shifts to the employer to say, no, I had a legitimate reason. So as you point out, so easy to find any legitimate reason, right? Like it's just so easy. You can find anything to say was a legitimate reason. And what's so interesting, and so it's just so fascinating, is the use of data and metrics, right? So like employers are the ones that control the metrics. And this is the discussion we're having in the DEI space too, right? And, there's a lot of distrust on the metrics that are being provided, but often what happens is the employer can be like, oh, well, this person, look at their numbers, their sales numbers. They didn't make their sales numbers. That's a legitimate non-discriminatory reason. And then if they show that, then it shifts back to the employee to prove that reason was pretext. So was pretext for discrimination. And as you correctly pointed out, it's really hard to do that. And it's very hard to do that in, this particular district. So Georgia, the way it works, this is a federal law. So we're in the 11th Circuit. So the 11th Circuit is, it's the federal courts in Georgia go up to the 11th Circuit Court of Appeals. The 11th Circuit is very employer friendly when it comes to those decisions.
Wow. Yeah. we don't have that many laws to help us as far as being employees.
No, no. We sure don't. And it's and again, I didn't really even know. I mean, I'd been an employment lawyer for several years before I really started getting into international employment law. So like once you learn how other employment laws work, you can't like unknow that. And then you start sort of seeing how our laws really, it gives employers a lot of power. It gives employers a lot of power.
Yeah. At will state.
Yeah.
So let me ask you this. So what are some things that employees can do themselves before contacting an attorney?
So I would say before you contact an attorney, put your timeline together. So like if it's about a dispute, for example, like if you want to know, hey, do I have a case?
Right. Yeah.
Put together like a timeline, write it out and put the dates on it. And because that'll help you through the conversation with the attorney. It'll help the attorney give you the best advice about your case. The attorney will probably ask you questions that you don't necessarily know the relevance of. And in employment issues, sometimes it's really like it's really sensitive and traumatic. And this is something that like I think is really it's really difficult because nobody wants to be a complainer. Nobody, people are mistreated, and the way that people will accuse you of playing the race card or playing the gender card, it really makes people feel like guilty about even talking about some of this stuff. So it's if you get up your courage to go to an attorney, right? Like it can be a difficult conversation. You need to feel comfortable with that attorney, right? So like if I would say in that conversation, if you don't feel like if you don't feel like that attorney's supporting you and hearing you, and like, sometimes it's just going to be hard to talk about, but if the attorney seems like it's making harder for you, like that's probably not the right attorney for you. So, that's really what I would say in preparation for asking the question of an attorney. So put that together in terms of, and in terms of what kind of research you can do. I think it's hard to figure out what your legal claim is before you talk to a lawyer. And I think it's really hard because a lot of times the answer is you don't have one, because
that's a lot of times.
And that's just hard, right? And like if people call me and I have to tell them that, right, I try very hard not to make them feel like, invalidated or rejected by that, because the laws are problematic. But there's actions you can take, sort of back to where we began, like in the workplace. I would like to see more constructive dialogue before people need to feel like suing, right? So that has to come from the top. It shouldn't be the burden of the people who are in the workforce to do that. But sometimes, you have to do the best you can in the situation you're in. So even if you don't have a legal claim, you still like a lawyer might still be able to help coach you through a situation. So did that answer the question? Because I wanted to make sure I understood that question correctly.
It did, because I was going to ask you too, because the question was in preparation of going to see an attorney. So with the person, because I've always been told that HR is supposed to be a resource, right? And so when you go and you talk to HR, who a lot of times is for the employer, then if it goes past that, you've exhausted all of that, is the next step maybe to talk to the EEOC? Is that a department a agency that you can actually talk to get advice on what to do to go forward?
Yeah, so that's more of like another half hour to answer that. 2 minutes, but the 2-minute version of that is check your policies, right? Like if you go look at your policies.
Okay.
If you don't look, HR, I feel for HR people too, right? It is a very difficult function.
Yeah, it is.
And right now there's a lot of structural tension. What is the function? But it is true. You're right that sometimes HR is for the employer. Ask yourself whether you trust HR. And if you don't trust HR, don't force yourself to trust HR. You don't have to go to HR first.
Okay.
There's look, the law wants you to go through the employer's processes if you can. But if you ask yourself, you know what, I don't trust HR because, I know HR is covered for this person in the past or whatever. Yeah, you can go to the EEOC. You can talk to the EEOC. As mentioned, they might be on a backlog, but the people I've talked to there are very nice. But they, again, it's a resource thing. But yes, you can talk to the EEOC, and you should know that if the EEOC decides you don't have a claim, you can still bring a lawsuit. You just have to go through the process.
Right.
And even if the EEOC says no cause, you can still bring the lawsuit. It's just a process you have to go through. So yes, you can go to the EEOC. You can go to someone internal that you trust. You shouldn't don't feel bad if you can't find someone internal that you trust, because that person doesn't always exist.
But you know what, you did say one key thing that I think we don't do, and that's find the policy and read the policy, right? Because I think I totally agree with you. You should start there, because no matter which direction you go in, they're going to ask, well, what does the policy say?
You want to know what
you want to know.
You want to know what the company wants you to do. That's useful information, even if you can't go, you can't do it.
Right.
But I help organizations write policies, and I hope that since the Me Too movement in 2017, there's been a shift towards better policies that aren't, because a lot of policies that were written, 5-10 years ago really helped push everything under the rug more. In some ways, because people were not reporting things.
Right.
But now we're starting to really focus, at least I hope that this is a change that is being made, focus on, we really want to make people feel safer to bring concerns.
Right.
And, I hope that trend is something that can continue. And I hope that it expands to other areas of the organizations.
Yeah. So if someone wanted to contact you, we have your information strolling at the bottom of the screen, but what is the best way to contact you if someone has a question or just wants to reach out to talk to you about maybe their specific situation?
Email is great. I'm also on LinkedIn, just Bonnie Levine. You can look me up. So yeah, email is great. I guess I'm right on the cusp of that generation who doesn't like to get cold calls. I'll take a cold call, but I just it's harder to get me to just pick up the phone. But
yeah, I think that's anybody though. You get so many spam calls. Today it's like, okay, it may be a legitimate client.
Right?
But let them go to voicemail. So yeah, but email, you can, person can talk to you and tell you in detail what their need is, and then you can fill them out a little bit better than answering that call. No.
Yep.
Well, Bonnie, thank you so much. I cannot believe this hour flew by.
I know, it did. We were talking for a half an hour beforehand too. Yeah.
We were. And you gave so much good information, a lot of good information you gave. And I just really appreciate that. We all are either currently employees or have been an employee or have employees.
Yep.
And there's so many things. The mindset shift you were talking about earlier has to happen, right? Mm-hmm. Because we're in 2022, and the things that worked in 2010 or 2012 and 2015, they don't work anymore. And there's been so many things that has happened in the U.S. since then that has changed the dynamics of how, we have to work as employers and things that we should know as employees. And it's all about education. And both sides need to be educated, right? Yep. And understand the importance of the DEI department that they put in place and work that department where it can help everybody. Like you said, it's supposed to be an umbrella covering for everybody.
Right.
But I learned a lot.
It's supposed to facilitate the work of everyone, especially the people in charge.
Right. I'm gonna remember that. I'm going to remember that. Now I know the full purpose of it.
I mean, look, I'm not saying that message is always well received when I tell my clients.
No. I totally get it. I totally get it. I totally get it. But that's the purpose of it, And I think we should know that. I think it's also important that as an employee, you have to know the resources that are there. Right. And especially when you work for big companies, they are full. What I've learned is that they are full of resources to help you. help you grow and help you navigate through different things that happen. And if you don't know, you start to feel helpless. So like you said, I want to encourage everybody, find that policy, read the policy, and also learn about the different resources that the company has to help you as an employee. FSAP, you have different things like that are there to help. The counseling department, they have different departments to help employees, and I think we should take full advantage of it.
And employers need to do a better job of explaining to employees where they can address those resources, where they exist. As a new small business owner myself, I really, I hope, to small business owners, I think small businesses have a lot of exciting opportunity to be the leaders in doing this, just doing it better, like doing a better job of treating our employees better.
Yep, I totally agree. Start small, influence big. Well, you hold on, and I'm going to tell everybody thank you so much for tuning in tonight. You will find us next week, same time, same place. Good night, everybody. You hold on, Attorney Levine.